Professor David Weisbrot took over in March from Julian Disney as chair of the Australian Press Council. And as many of us well know, the Council has been through a quite tumultuous era in recent years, as has the media industry. And of course, we've had big issues with media inquiries and governments that think government regulation would be preferable to self-regulation of the print media. Mercifully, we've moved beyond that. In the months since he's taken over in this role, I think David has proved to be quite an agent of change. A lot has happened within the Council organisationally, much of which sounds commendable, and certainly in the public space we've seen him speaking very effectively and powerfully on some critical issues in terms of press freedom and the ability of journalists to do their jobs. So it is a great pleasure for us at the Melbourne Press Club to welcome him here today and to hear more from him about his ambitions for the Council. David Weisbrot brings a very impressive pedigree to this job. He grew up in New York. He studied communications and political science at Queen's College and law at the UCLA. He spent 5 years working in Papua New Guinea and the Micronesian Islands and moved to Australia in 1979 to take up a lectureship at the University of New South Wales. He became the longest serving president of the Australian Law Reform Commission between 1999 and 2009, and during that period he oversaw high-profile national inquiries into such issues as the handling of classified and security-sensitive information, sedition laws, secrecy laws, privacy law and practice, and protection of human genetic information. He was previously Dean of Law and then Pro-Vice-Chancellor of Humanities and Social Sciences at the University of Sydney, and is now an Emeritus Professor of Law and Honorary Professor of Medicine. I'm not quite sure how that happens, but I'd love to hear. David has co-written and co-edited 10 books and hundreds of official reports, book chapters, journal articles, and conference papers. The man is impossibly well qualified. David, I might say, and we had a few exchanges preparing for the lunch today, I learned a few things, including he doesn't like the word watchdog. Fine journalistic shorthand for an organisation like the Press Council, I would have thought. But I don't think that suggests that he thinks the Press Council should not have teeth. He also fancies himself as a bit of a headline writer. His title for today's address, which unfortunately busted as a headline, is Adventures in Media Counter-Errorism, the challenges of heading up the Press Council in an era of technological convergence, social change and stifling surveillance. Excellent. I did suggest that Adventures in Disneyland might be an alternative, but that didn't wash. So anyway, it's a great pleasure to welcome David. Please welcome him.
As a great former US Vice President Dan Quayle once said, before I begin speaking, I'd just like to say a few words. So thank you very much, Mark, both for inviting me to speak today in the first instance. As you said, this is really my first foray speaking to my new target demographic. And thank you very much for that very warm and generous introduction. I can confirm that there was a gentle tussle between Mark and myself over the precise topic for today's event. And as is often the case with two people who are both polite and stubborn, we approved of the other's idea generously. Hold it.
Sorry to interrupt.
Okay. We approved of each other's ideas, but pushed our own a bit more strongly. It reminded me of a fantastic bit of phrasing, which I wrote down at the time, by Larissa McFarquhar, who's, as you may know, a lead writer, fantastic writer with The New Yorker. who said, "Everyone knows how to damn with faint praise, but damning with with extravagant praise is a more esoteric enterprise, the more so because it's frequently unintentional." And so ultimately I was won over by Mark's utterly brilliant and strikingly original compromise suggestion of the new Press Council, SEL, lunch with David Weisbrot. Can't argue with that. I mention all of this only because the exchange really was emblematic of the themes at play since I took over the chairmanship of the chair of the Press Council about 5 months ago. And I've set out to change the culture of that organization and its perception, and in so doing, to increase its effectiveness. Mark's original suggestion, as he mentioned, turned on the Press Council being a watchdog, or in some other way serving as the cop on the journalistic beat, which in fairness is probably what most people and most journalists think about when they think about the Press Council, if they think about it at all. What I wanted to run with, as he said, is adventures in media counter-errorism, partly because that was a great pun I thought of, and I wasn't going to let it go to waste, so I wanted to try it out on you. Mixed reaction. I may use it again, I may not. I should say this time last year, almost to the day, in fact maybe to the day, I was blissfully sitting around the pool at my resort hotel on Santorini in the Greek islands, and the phone rang. And I thought, well, it must be one of my kids. Who else would ring and know the right time of the day to ring me in Greece? And so I answered it faithfully, and it was the headhunter saying, "What do you think about becoming the next chair of the Press Council?" Well, the way you can do things these days, I didn't have to put down the drink in my other hand. I just had to balance my phone, click through to LinkedIn, type 3 words, yes, maybe, question mark, question mark, question mark. I don't think I used emoji in those days, just a year ago. And so in that fateful decision, if I had been in the water at that moment, I wouldn't be here speaking to you now. But was I interested? Yes. Yes, I was. As Mark mentioned, I started off my academic career doing communications and politics degree at Queens College, City University of New York, the working class kids college that takes you through with parents who almost no kid who went there had a parent who had gone to university. So it was the migrants' success route through to American culture. And of course, while I was doing communications and political science, I envisaged myself constantly as being a dashing foreign correspondent, come and returning to do brilliant bits of investigative reporting, and then covering major sporting events so that I could get in free to those. I was also an editor of my, I proudly say, award-winning university newspaper, which was a daily, hard to believe now, but published daily, and it had a circulation larger than many major newspapers in Australia do today. So yes, I was interested. I've always been a voracious reader of the media. I still keep in touch with American, Canadian, Pacific Island, UK media, while I devour all of the Australian media as well. And I'm one of those rare people, I guess, beloved by publishers who's actually willing to pay for the privilege of reading some very good content. I also love a challenge. Another way of putting that is that I've traditionally been a glutton for punishment. And so the thought of leading the Press Council at a fairly turbulent time, I think would have turned off many other people. But I thought, what would be the fun in just going somewhere and marking time? And the fun is getting in there, putting your stamp on an organization, trying to lead it through the difficulties, trying to think through the difficulties. And so that's why I loved law reform. It's why I didn't love being a dean, but it's why I loved law reform, because you're working on practical problems that people care deeply about, And you're actually, unlike my academic career where I deconstructed everything within an inch of its life, as a law reformer, you actually have to have some solution. You can't say to government, this is all terrible. They know that. That's why they referred the problem to you. You have to say, here is what we're going to do with this that will improve Australian life, Australian society, equality, access, equity in Australian society. And so I dealt with a lot of relevant issues with mixed success during my time at the Australian Law Reform Commission. I think we did a pretty excellent job on privacy laws, many of which have passed into legislation. It's a great tragedy that John Faulkner didn't remain in that ministry long enough to see the whole project through. But I think we did some good things. We did some semi-good things with the handling of classified and security-sensitive information, although the government really wasn't interested in doing much of what we suggested. I personally wrote the report that recommended the abolition of sedition laws, and I'm still to this day very proud of that law reform effort. And I also was one of the people intimately involved with writing the Essentially Yours, the groundbreaking report on genetic privacy and discrimination, which really makes Australia one of the leaders in that area. You don't read about it much, you don't hear about it much, but we have a protective social platform in that area that most countries in the world go to when they're looking at how to reform their own laws in that area. So I metaphorically threw my hat into the ring with those few clicks. A few months later, I came back to Australia, had a couple of interviews. I found out that the situation was even a little bit more dire than I feared when I was telling friends and family that I was applying for the job. And they said, you were away, but have you seen all these stories lately? And I truly hadn't. I had no idea. So I was sitting at my computer late one night rifling through them, and I thought, I don't know whether this is right. But if, as Neville Rand said, if famously Balmain boys don't cry, then Brooklyn boys scare even less easily. So now that I find myself in the position, I find that I need and I utilize all of the diplomatic experience that I gained as a law dean and as a pro-vice chancellor, as a state and federal law reformer, and so on. So I feel confident that I can create a safe and respectful enough environment for competing interests to crash and collide at the Australian Press Council, but for complainants and publishers and the general public to feel that the system that we operate has enough integrity, enough pride, and enough goodwill and independence to do its job and to lower the temperature pretty substantially. So the traditional Press Council, the Press Council was established in 1976. We will be celebrating our 40th anniversary, and Mark, we should talk about inviting speakers together and so on. Our 40th anniversary in May 2016. We're proposing to hold a major international conference around the theme of press freedom in challenging times and exploring some of the contemporary press freedom issues here and overseas, particularly in our region. And not only the ones we're facing now, but the ones that are likely to come over the horizon. In my capacity as being new on the job, I've been trying to meet with editors and senior journalists wherever I go. And interesting how many have strong views, not concluded views, about where traditional journalism is going or where newspapers are going, whether there will be print journalism in 10 years, whether it's all going to go online, whether there will be newspapers as we traditionally know them, or it's all going to be Google dash something or Facebook dash something. So I think we need to explore those issues too about what we're talking about when we talk about press freedom and journalism down the track. 1976, as the establishment of the Council, was no coincidence. The Council gets its biggest boost whenever a government suggests that there might need to be greater public regulation, formal regulation. So Whitlam made noises in 1975 about establishing an independent media monitor, and that was going to be a statutory officer, similar powers to what we now know as ACMA, but in relation to the print media. There's no online media, of course, at the time. And so the newspaper publishers got together and said, well, we can't have that, so let's do something significant ourselves. Let's look around the world, the British Press Council and others, and develop something that will forestall the creation of a public regulator. And when the Gillard government, several years ago, talked about, or revived ideas about that in the wake of the Levinson inquiry and the Finkelstein inquiry, then the Press Council suddenly got the Australian Press Council got new powers, new resources, slightly augmented role, greater coverage of online, and so on. So where are we at the moment? It isn't the old Press Council from the early days that you probably picture, which still operates largely in other countries. But the Australian Press Council now, the publishers form only a minority. So of the 24-person council, there's myself as an independent chair. There are 10 public members, some of whom are here today, very distinguished members of the community who are chosen for their independence and their robustness and their integrity. We then have four independent journalists, people who are by and large distinguished journalists who have retired from active practice, are no longer on a payroll. The council's funding is now assured on a rolling 3-year cycle, so we know what our budget's going to be 3, or actually in practice 4 years out. And so we can hire staff confidently, we can do the job confidently and feel a certain sense of safety. Publishers, importantly, are no longer involved in hearing or determining complaints. So that work is done purely by independent panels that include no publisher representatives. My executive director, John Pender, is here today, and myself went to visit the New Zealand Press Council a few weeks ago and observe how they do things. And their publishers sit on the determinations, on the complaints determinations. Of course, the ones that are directly involved withdraw from that particular one. It worked pretty well, but I still think that the independence we get in Australia by not having publisher reps directly on the council is very important. There's something like 80 to 100 press councils around the world, about 60 of which are active and operate in association with a free press. And now that I'm involved in a internet discussion list with many of them, I find that most of them are quite envious at the resources we have at the Australian Press Council and of the powers that we have. So I think we're doing pretty well in that respect. I pay tribute to my predecessor for securing that situation. And yet, if you get most of your information from the Twitterverse, which increasingly I do, although I'm trying to not make that my exclusive source of news and views, what you see mostly is that old lazy cliche. The press council's a toothless tiger. It's a toothless tiger. It's a toothless tiger. And so I followed one of those threads recently. I thought, what's the basis for this? And you never see any sound analysis or any facts and figures or any cases that are trotted out to support that assertion. Find me a case where, we operated in a way in which we were toothless. We couldn't deliver. We showed cowardice. But that's never it. It's usually, here's a case. What is a press council going to do about it? We assume they're a toothless tiger, and then you track through it. So I followed one of these exchanges recently, and it was fascinating. A toothless tiger, and then all the people coming in underneath, toothless tiger, various forms of that. And then finally the person who had started saying, And this was the substance of this was that a certain newspaper chain, which shall go nameless, was overly supporting and uncritically supporting the Abbott government's initiatives. You won't be able to guess which one I'm talking about, but nevertheless. So they said, this is terrible. We could complain to the Press Council about this uncritical coverage of the government, but it's a toothless tiger, won't do anything about it. So on and on and on. And then finally, the person who started this thread said, yeah, what we need is a statutory office holder who's going to hold the papers to account and who has the power to do this, a government officer to do this. And I thought, isn't that person going to be appointed by the government that you were just saying you really don't like? So no thought whatsoever about how to improve the system. Now, I believe that the Counsel is doing an effective job and doing it with integrity. If I didn't have that view, I would resign immediately and go back to Santorini and assume that exact position I was in when that phone so fatefully rung. And I think that far from being a toothless tiger, the Press Council would maybe more be fairly characterized as a terrifyingly tenacious terrier. So we might not kill you, but we'll give you a nip around the ankles you won't soon forget. That was meant to be funny. Okay. So my perception, or I think public perceptions about the way the Press Council operates are heightened often by the press coverage of the Council itself. There's not much coverage of the development of standards, not much coverage of education, and much of the coverage is based around or resembles sports reporting or war reporting. So the Council's had a win over this particular press outlet, or we lost one there, or it was an honorable draw. And then when we do we do uphold a complaint, then the publisher is said to have been rapped over the knuckles, censured, slammed, or my favorite one recently, lashed. So what we're doing here, of course, in those cases is these are the aberrant cases. We receive about 500 complaints a year. Increasingly, we receive them from a larger and larger number of complainants. And most of those cases are resolved quite quickly and with a remedy that is pleasing to the complainant. But those don't get that kind of coverage, of course. It's only the aberrant case that goes all the way through to an adjudication. What we do, of course, in most cases, I think we do a good job on behalf of complainants in getting those. I'd love to ask Joe Hockey now, in an honest and reflective moment, whether he would have been better off lodging a simple complaint with the Press Council for free than issuing defamation writs and pursuing a high-cost, high-risk litigation strategy. So for the broader public, as I said, we get about 500 complaints a year, about 10 a week. There are about 700 complainants represented there because more than one person often complains about the same articles. In the public confidence, I think, in this system may be demonstrated by the fact that our complaints have increased by about 13% or 13 to 15% in the last year. We've seen an extraordinary jump in the number of complainants by about 400%. And that's the influence of social media. So social media petitions now go around saying, do you also hate this article that X wrote? Here's the way you complain to the Press Council, and maybe here's a form of words that you might want to use as well. Now, that doesn't strengthen our conviction about whether a particular article breaches the Press Council standards, whether there's one complainant or, as recently was the case, 800. But it does make our life much more difficult in trying to manage a complaint with 800 people. Are any of them actually the affected person named in the article? Are they family members? Are they just unhappy? Do they just hate the writer or the paper? or do they actually have some material information? We have to go through all of those, of course, to sift that out. So what do we do with complaints? Well, so we get about 10 a week, a couple a day. We have meetings every day in which our staff look at the complaints that have come in, and we begin to analyze them. We then enter into a triage process, and once a week we take the most difficult cases that are likely to go forward, and the senior managers at the Press Council analyze those and determine what to do with them. If you take the total pattern, the 500, about a third of them are dismissed relatively quickly, sometimes more quickly than others. And there are various reasons why that might happen. Sometimes, quite often, those complaints express a general dissatisfaction. So I hated that article, I was disgusted by that particular article. But there's no allegation of any breach of the particular standards that we have. Sometimes they're trivial in nature. You learn that there are many people in the community who are very expert at very tiny things and pick up little, that flag had 1 star too few, so it couldn't have been the flag in that particular year, those kind of things. And if it's not something that would have seriously affected the ordinary reader's perception of the issues, we're not likely to take that forward, although we might bring it to the attention of the editors for future use. Some of the complaints pertain to television, radio, or advertising, and we don't handle those, so we refer them either to ACMA or to the Advertising Standards Board. Another third of complaints are withdrawn or discontinued. And quite often we find people get the complaint off their chest, so they write that letter in which they say how awful it all is, and then when we contact them for follow-up, can you give us a bit more information? Can you tell us which article exactly it was? They're not that interested anymore. They vented. We're happy to be the ventees, but there's nothing more that we're able to do with that, and quite a few of those. And we get some of those sometimes around highly technical issues. For example, some of the climate change articles, we get people writing in saying that description of the intergovernmental report in that area is completely wrong, and they've got it completely wrong and it must be corrected. Well, we're not climate scientists at the Press Council or meteorologists, so we go back to the people and say, could you give us some facts and figures? Can you plug us into the right bits of the intergovernmental report so we can put something to the publisher and see what they say? And then we often get that, well, no, much too busy. I've got to go to a climate science conference, so I can't give you that information that you need. So there's nothing much we can do with that. I guess it's a different form of venting. About 25% of cases, we can get a good, quick remedy. This happens all the time. So the person said, that photo of me, in which the person's described as an armed robber, that's me. Oh, sorry, that's a photo. That's me. But that's not the person who was arrested for armed robbery. It's a mistake. It's a person with a similar name. Or that story refers to me of having criminal convictions. I was never convicted. I was arrested, the charges were all dropped. So we can call the editors and the journalists and say, look, we've got pretty compelling evidence that that's wrong, that photo is not the right person, that information is incorrect or out of date. And with the cooperation of the industry, that stuff is normally corrected very quickly and unproblematically. Sometimes it's a correction, sometimes it's a takedown, sometimes it's the publication of a letter to the editor or an op-ed piece, but that is what complainants really want most of all. The remaining only 5 to 10% of cases go through to full adjudication. 3/4 of those result in an uphold. 1/4 are ultimately dismissed. But nevertheless, even the dismissed or not upheld adjudications, I think, are valuable as educative tools for the industry, saying, this is what we require of people. In this instance, although there were some legitimate issues that were raised, we think the newspaper concern met its obligation. So this pattern, interesting, we've been doing some benchmarking with other kinds of dispute resolvers, ombudsmen, industry ombudsmen, across a wide range of areas. And that pattern of a third, and, or nearly a third, nearly a third, nearly a third, and then a tip of the iceberg is quite common across the board. So we're pretty sure that we're dealing with those in a sensible way. I should say that the Counsel has no power beyond that to try to negotiate remedies with the publishers concerned or to take something through to a formal adjudication. We have no power to censor, although we're sometimes incorrectly referred to as censors. We cannot administer a fine, as IPSO, our UK equivalent, can. We can't publish or ban an individual journalist. We can't shut down a publication, as ostensibly ACMA can do in relation to a radio or TV licensee. And I should say we have no desire whatsoever to have any of those powers. I think that would dramatically change the nature of regulation and change our relationship with publishers in a way that would not be conducive to serving the best interests of the society or complainants. So given that I've spoken in relatively flattering terms about what the Press Council already does, why am I trying to change so many things? Well, I think it's working reasonably well, but I think we can improve things further. First, if you ask anybody who's dealt with the Press Council what their major grievances around the Press Council's operations is that it takes too long to go from initial complaint through to a published adjudication. It can take anywhere from 5 or 6 months or even up to a year. The Mayang Prosciutto case that was in relation to the front page of the Courier Mail that was reported yesterday took nearly a year for that to go all the way through. But it's a very complex process to take those really difficult cases and to make sure you've drafted a really good judgment and to allow a lot of legal processes to go to run alongside or to be concluded before we push ahead. So what I'm looking at is streamlining, some methods of streamlining or refining the process. Part of that will be aided greatly by new information technology. We still have a very old-fashioned system that involves lots of paper. Pretty environmentally unsound, parenthetically, we will improve that. But if we can mechanize and routinize our processes, and there are regular software programs that are available for that, we should be able to speed things along much more quickly, capture more information initially, contact our complainants much more quickly, and move our way through. Now, those issues of delay are the bugbears of every litigation system or every complaint system in every context around the world. At the Law Reform Commission, I led the major managing justice inquiry that looked at the efficiency and effectiveness of the federal court, family court, and administrative tribunals in Australia. I did a similar project as an independent consultant for the Israeli government, and I've looked at those issues around the world. Every system that's complex and involves people's rights and responsibilities and the resolution of complex disputes takes a long time. And it's usually too expensive. At least in our case, it's completely free for complainants. So what we're trying to do is to streamline things. We're going to upgrade the technology, the complaints forms, the software, and the databases. We're trying to improve the triage process. So I've removed myself from the final stage, which only deals with 5% of adjudications, and put myself actively into the triage process, which involves 100% of complaints. And that's true for all of the senior managers at the Press Council. So we're trying to add value at that early stage rather than later. We're adding another, importantly, and this is just coming in now, we're adding another track to the adjudication process so that we will have a so-called streamlined or fast-track procedure, and rather than going to a 5 to 7 person adjudication panel, we're having a 3-person panel, and it will be heard entirely on the papers rather than with the participation of the parties. Hearing it on the papers is how New Zealand does it. And so we're hoping that we can take a lot of the complaints in which nothing much is really added at that late stage. All of the issues are clearly identified early. The parties have had a chance to talk about their feelings about the matter, and we will try to get those through much more quickly. I'm also trying to change the culture from that policing one to a more collegial and educative one. So I would regard this as a shared enterprise, that media ethics, that good practice, that maintaining public confidence is something for the entire industry. It's not something for an independent cop on the beat. So we're trying to shift some of our energy through to the educative role, sorry, and to create a different culture, one that's more collegial and intelligent and continually learns from the experience. In my former life, I was involved in developing the complaints process that's used in relation to lawyers in Australia. And what we found there is that law societies at the time, it's now been largely replaced with independent legal services commissioners or ombudsmen. There's one in Victoria, one in New South Wales, Queensland, the ACT, and so on. But the law societies would take each case as an individual one, as one bad apple, and say, and the paradigmatic case usually involved clients saying, I just can't get anything out of my lawyer. This thing's been running for 2 years. I have no idea where my case is at. I occasionally get bills, but I get no other communications about where my matter is going, is heading. And so the Law Society would write a letter to the lawyer and say, you know, we've received this complaint. Could you please do something about it? 3 months later, they would not have heard a thing. So they'd write to the lawyer again and say, 3 months ago, see attached, we wrote to you saying that your client complained that you weren't very good at communications. Could you please communicate with us on this occasion? Tell us where this case is going. 3 months later, nothing. So after 6 months, they would write and say, under Section XYZ of the Legal Profession Act, we are going to suspend your practicing certificate unless you immediately communicate with us, cooperate with us in this investigation. And the next day, invariably, the lawyer would write or phone and say, here's what's happened, I've called the client, this is going on. And the Law Society would look at that and say, okay, case closed. Now, it was receiving hundreds of those kinds of cases a year. And the lesson it should have drawn was, we have a problem in the profession with communication, with practice management. There are particular sectors of the profession that are worse than others. What's happening with burnout in certain sorts of firms? What are we doing to educate lawyers about this? So we're trying to draw on that kind of experience and move away from a system that targets, or move partly away from a system that targets individual transgressions to one in which we learn from the entire pattern of complaints and complaints handling. And so we can better and more strategically achieve industry-wide improvement and reassure the community that this is the case. And I should say there's been considerable interest from newsrooms around the country in having the Press Council come and talk to journalists, to cadets, to editors, to talk about the complaints experience more broadly, to talk about the new, relatively new general principles that only came in a year ago, almost to the day, and to talk about what we're hearing as part of that complaints process. And what are we hearing? So it's interesting, since I've started, well, I should say first, the general principles don't need any work. They came in only a year ago. They're very good, they're very clear, and they're now predicated on the idea that papers have to take reasonable steps to achieve these things. So we understand that stories break, that the police provide initial information that turns out not to be correct, that life is complex. But what you have to do is take sufficient steps to make sure you're doing everything you can to get it right. So you've got to be accurate, you've got to correct material that is found to be inaccurate or misleading, you have to give reasonable fairness and balance, provide a reasonable right of reply, all those sort of things that you could readily anticipate, even if we didn't have 8 written general principles. But we're able also to augment those with specific standards that look at reporting in particular fraught contexts. The most famous of these is in relation to suicide. So as you're all aware, the Press Council brought in a specific standard on reporting of suicide several years ago, and it has completely and successfully changed practice. So you don't get reporting in great detail about the method of suicide. The stories are not overblown and melodramatic. They always end with that caveat that says, if you're feeling upset or depressed, here's the hotline number, here's where you can go for help. We get pretty well 0 complaints now around the reporting of suicide. So we're saying, well, there's a great example of being proactive, thinking about what the issues are, and not changing practice by whacking journalists who make a mistake or report in an incorrect way. We're going to change practice by saying in advance, look, there are much better ways of doing these things in the public interest. So what are some of those things we're hearing now from the complaints experience, whether these are individual complaints or groups contacting us and saying, we're pretty unhappy with the general tenor of reporting. And here's a bunch that I am going to investigate much more fully and take through to the Council over the coming year. First, the reporting of family violence. We're getting a lot of feedback that people in the community are upset about family violence stories that even hint at blaming the victim, that treat children as part of the contest rather than as victims as well, that provide too much grisly detail about the violence rather than about the horror of the violence. We spoke yesterday to Justice Marcia Neave, who's conducting the Family Violence Royal Commission here, and she strongly endorsed the idea that we might provide better guidelines to journalists about how to cover those sorts of stories. Similarly, we're getting significant numbers of complaints about the reporting of child sexual assault, that often it involves too much detail, that it creates hurts for the people who were the particular victims, but also for other victims of child sexual assault who see that and relive their own experiences. So are there better ways that we can do that, as we have with suicide? We've had significant numbers of complaints about the reporting around LGBTI individuals and issues. Although I should say mainly it's about the T at the moment. Most newspapers are now quite respectful in talking about gay and lesbian people. They don't use slurs, don't use colloquial language, don't use headlines that would be upsetting for people in those communities. But there's still issues around reporting around transgender, and you saw one particularly poor example the other day in our adjudication that we reported, in which we did uphold the complaints about the Courier Mail's reporting of a transgender woman who had been quite savagely murdered. So what we're suggesting there is we may need to develop better guidelines. We're certainly pointing people, with bad use of the word, as you'll see in a moment, to the Pointer Institute. Guidelines of Pointer Institute's a nonprofit institute in America that's devoted around media ethics, and they've developed some quite good guidelines, I think, around reporting LGBTI issues. So do we need something in Australia? Respectful reporting around race and religion. Not getting so many of those complaints at the moment, but around the time of the Martin Place siege, we were getting contacted by quite a few people who were saying, we're very uncomfortable with the quick elision from this person is a Muslim to Islamic to Islamist to fundamentalist to terrorist. That's being used, and the use of the term jihad and the Shahada flag are being used in ways that make our community uncomfortable. Not so many complaints and very few specific complaints at the moment, but again, these are things we can think about. On a different note entirely, we're starting to receive complaints about newspapers with the rivers of gold having dried up, now engaging much more in so-called sponsored content or native advertising. So there's a widespread appreciation in the community that that's okay broadly, that newspapers have got to have and online services have got to have a viable online financial model, or they won't be there for us when we need them. But we don't want to be fooled. So it's the duping aspect. And the few complaints that we've got that were really pointed said, I was halfway through this article, I started reading it because I thought it was a genuine, independent comparison of insurance schemes or small cars or whatever it is. And then I got 3/4 of the way through and I realized it was an ad effectively for XYZ. So that's when people get angry, that they feel they're reading news, they feel they're reading editorial, and it turns out it's an advertorial. So how do we deal with that? Well, obviously better disclosure, better labeling. There are ways of doing that, and we think we can give newsrooms some pointers, or editors some pointers about how to do that. And then two areas in which we're starting to see an uptick in complaints and concern. One is in the appropriation and publication of online photos, so especially where they involve children. So journalists going to Facebook pages and saying, well, that's a public setting, so I can take that picture. Or there's nothing really good on the public setting, so how about I friend that person? And then they feel flattered and friend me back, and then I have access to a whole wider range of pictures. Does that mean it can be done? So we're starting to see complaints that are linked to the appropriation of images from Facebook, Instagram, Snapchat, and so on. Well, should we have a little bit more guidance about that? We're going to look at that. And then finally, what about the so-called right to be forgotten? We're starting to get those kinds of complaints too, saying this, I was convicted of some crimes as a young person. I've had a blameless life for 20 years. I've even, under the laws in my particular jurisdiction, that's considered a stale conviction, spent conviction. But now, and no one could have found it previously, no one was going to go through the Supreme Court's microfiche collection to try to find out whether I had committed any offense. But now a quick Google search and wham, there I am on the front page of a particular journal in a with a balaclava in one hand and a gun in the other. So should we be doing anything? Now I'm profoundly uncomfortable about the right to be forgotten to the extent that it alters history, that it deletes valid information that we need in the public record. There may be very good reasons why we want to track people's backgrounds if they're now in positions of trust, but do we need some protections that restore some balance between spent convictions and modern needs for reporting? And then finally, we're looking at trying to broaden the membership. We very proudly say often at the Council that we've got every newspaper in Australia except the West Australian, for some interesting historical reasons. Those of you who spend a lot of time in West Australia, as I do for friendship reasons, know that they feel differently about local things and have that keen pride, that keen concern about everything being local. But we've got 95% of English-speaking language circulation, and we've got 850 mastheads as part of the Press Council. We've increasingly captured online journalism to match the print component. I think 16 or 17 of the top 20 most visited online sites are members of the Press Council. What we don't have at the moment, and I think it's a glaring omission, is any recognition that we live in a very vibrant, diverse, multicultural society. We don't have any Chinese language newspapers, Turkish, Arabic, Vietnamese, Greek, Italian, or other. I'm just shocked that no one else in nearly 40 years has thought this to be a significant problem. And so we've now engaged on a very active campaign to try to bring the multicultural press into and sell them on the advantages of the Press Council, bring them into the Press Council so they're involved in policy setting and their readership can bring complaints if necessary. We've just had translated into Mandarin our general principles, and next Friday we're going to have a press conference in Sydney with leading Chinese editors and journalists and proprietors and political leaders and business leaders to try to change this situation. Okay, and what I also want the Council to be involved in very actively, this is my last area, is much more actively involved in advocacy for free speech and freedom of the press. So there was a view at the Press Council from its earliest days. The first chair of the Press Council was the retired High Court Judge Sir Frank Kitto, and he said, our job is to protect the free press by giving the public confidence in its integrity and standards, and that's it. We don't argue further. That's our role in the process. I think times change, and I've taken a very different view. I simply couldn't stand back and not speak out vigorously on behalf of the Press Council when I looked at the metadata retention laws, which I think are an outrageous intervention into the ability of the, on privacy of the general community and the ability of newspapers and investigative journalists to do their job. I think we also need to look at some other quite, I think, pernicious developments, including the amendments to the ASIO Act, the famous Section 35B, around criminalizing disclosure of protected operations. It's an extremely difficult area, but if you read the legislation in this area, you know where Franz Kafka's modern descendants have gone. They're now doing legislative drafting for the government around these issues. We've seen just recently also the criminalization of whistleblowing in relation to detention centers, so that certain categories of person, which includes lawyers, social workers, doctors, and others, who believe that there are child sexual assaults or other kinds of violence or mistreatment going on in the detention centers, and disclose that other than in a very, very narrow and prescribed way, and probably futile way, bring criminal liability possibilities upon themselves. We've seen a parliamentary committee look at so-called ag-gag legislation in which people who blow the whistle on farming operations that involve widespread abuse of animals are themselves liable to criminal prosecution. This all started in the US, and just yesterday, a federal court in America described this as a totally unconstitutional invasion of freedom of speech and freedom of the press in a way that would harm not only animal welfare, but public health and safety and the public interest. So why are we taking these discredited ideas and trying to bring them to Australia? So I'm committing the Press Council to getting involved very actively in these debates. When media proprietors do it, they can often be attacked as doing it in their own self-interest. We are doing it on a much broader social interest, and we ourselves reflect the balance of newspaper publishers and public interest, public members who can represent the public interest. So we're going to push very hard on that. You probably also heard me talking about the evils of current defamation law in Australia against a background in which we have very little or very flimsy constitutional protection of free speech. So I've committed the Press Council to work together with interested parties to develop a model uniform defamation law of which we can be proud, which protects to a much greater extent legitimate rights of reporting and holding powerful interests under the light. So and because I work like most people and all journalists, I work best to a deadline. I've committed the Press Council to doing this by our 40th anniversary in May. So we will develop a good model defamation law for Australia, of which we can be proud, finally. So I'd like to end with a challenge for you, members of the press. We are going to work very hard to try to get these reforms, to improve our own processes, to advocate much more vigorously on behalf of the press. But the reason we are arguing for press freedom is that that's necessary as an essential part of democracy, of holding of holding the power of the rich and the powerful, including government, to account. So we need the press to redouble its efforts to make that the focus of its reporting. I'm not fighting for free speech so we can hear more about the Kardashian family. I'm fighting for free speech so we have more people like Kate McClymont at the Sydney Morning Herald exposing serious corruption in our governmental processes. So let's do that together. We're going to work with you. Occasionally, we're going to have to point the finger at somebody for having transgressed the rules. But again, I believe this is a shared enterprise in which we are really all ultimately fighting for the same issues. So thank you very much for your kind attention.
David, thank you very much. Time is extremely tight, but while we normally pride ourselves at finishing at 2, if people are able to, we might stay a little bit longer for some Q&A, and I'm sure there will be some questions in the room. If I could ask people to identify themselves before they ask their question, and there is a microphone other than this one going around. No questions? Tony Thomas.
Tony Thomas from Quadrant Magazine. Coming from the US with the constitutional okay for free speech, how do you feel about our Section 18C denying the right to offend, insult, humiliate certain parties?
Well, I could come from almost anywhere, and I would come from a place with constitutional protection of free speech. As I say, Australia is alone among the Western democracies in not having that protection. It's really quite shameful. But in terms of Section 18C in particular, it's recognized everywhere, even where there are the most powerful protections of free speech, that it's not an unlimited guarantee. There are still, I can't, famously cry fire in a crowded theater. I can't conspire to commit a crime. And there are, even in the International Covenant on Civil and Political Rights, there's a specific section right after the free speech section that says racial vilification should be a crime. So we've got to balance those things. The question for me has always been not whether you have a right to be a bigot. I can't see that as the headline issue, frankly, in freedom of speech and freedom of the press, but where you draw the balance. I've always thought 18C drew it slightly too low, and that because it only talks about offend or distress or offensive language. I think if it just needs an adjective like seriously or something like that, just to raise it up one notch. then I think it would meet the international standards, the International Covenant on Civil Political Rights, and the legislation that would apply in most parallel countries. UK, Canada, the US all have racial vilification provisions. They have race hatred laws. Many criminal laws make racially motivated attacks expressly an aggravating factor. So I don't think it's improper to punish or to single out those kinds of attacks. But I think if you're balancing freedom of speech in the equation, then you have to raise it up a level. It can't simply be saying things that make people uncomfortable. It's got to be something that's really quite seriously threatening or seriously offensive.
Thanks for taking my question. Rebecca Urban from The Australian. Hi, just here. Your predecessor was quite critical of sectors of the media. I think he used the term powerful media players in his outgoing address, and I just wanted to see whether you concur with those views, and if so, whether repairing some of the relationships with those sectors of the media are a priority for you now?
Sorry, I missed the beginning of the question.
Sorry, I was referring to your predecessor made some quite critical comments in his outgoing chairman's address about sectors of the media, powerful players in the media, and over various issues. And I just wanted to see whether you concur with those views and whether that's an issue that you'll be taking up.
Well, I haven't encountered those problems directly myself. I think in Julian Disney, my predecessor's speech to the National Press Club, he talked about a problem of choosing selected journalists and therefore freezing out other media outlets. There's hardly a politician around the world who doesn't have their favorite talk show hosts and reporters and so on. So it's been an old story. It's not come up as a particular problem during my admittedly limited time at the council. So it's not been something that anyone has asked us to focus on. I'm not sure how you would write rules around that anyway at the press council level. I mean, it may be a matter for politicians to run a much more open and transparent system of government in which everybody can find out all of that information all the time rather than having it selectively leaked. Our FOI laws need a lot of attention. We constantly see government spending considerable amounts of taxpayer dollars in the Administrative Appeals Tribunal and then in the federal court trying to keep newspapers from getting information that really the public should have a right to. Modeling around, for example, modeling around the deregulation of university fees, but name your issue, there are dozens there. So I think there's a broader question for me, not so much about media ethics and that. If I was if you wouldn't want to say to Woodward and Bernstein, because Deep Throat gave you that incredible information about the Watergate break-in, you shouldn't use it because it was given to you personally and not to the press in general. But I think I'd rather attack it again in that broader way, as saying we need much more robust freedom of information. We need much more commitment to openness and transparency. We've seen it come up again in the so-called entitlements debate. We shouldn't even be having that debate. That information should be on every politician's website in real time as they spend it. And then they probably wouldn't be spending it in quite such a brisk manner.
David, John Trevorrow from Leader Newspapers. Just a quick question about traditional media. We've seen traditional media under an extreme pressure to keep the number of journalists in their newsrooms. I was just wondering, interested in your thoughts on how that sits with the idea of that shared enterprise of holding the rich and the powerful and governments to account.
Well, it was interesting. The St. James Ethics Centre runs a series of debates in Sydney and Melbourne and probably elsewhere. There was one not so long ago on the dinosaur, so-called dinosaurs of the traditional media versus the the quick and nimble, whatever animals they were, of the online press. And interestingly, the public came in supporting online. You're polled when you went in, and then you're polled after the debate. And it completely shifted over to the traditional dinosaurs by the end of the debate. And that was because the debaters on the side of the traditional media said, can you people in the online area allow a Kate McClymont to spend a year doing this kind of research and not publishing until she's able to do the research, and then backing her with $1 million fund in the event of defamation? The answer was no. We have 1.5 staff at our online outlet. We're doing a great job, but that's not what we do. So I think there's it is the commercial viability of the traditional media, I think, is essential to be able to do that kind of deep reporting. Now, whether the presentation of that is done in the same way, I mean, I'm not an expert in this area by any means, but talking to senior editors at the traditional media, they're often saying, we're unlikely to be in the paper-producing newspaper business in 10 years, or maybe we'll do it on the weekend. So I think there is a trend to online delivery, but I don't see that as the essential part of it. It's what's the content? And if we can allow enough robust content providers with a commitment to doing good investigative journalism and good political analysis, then I think that's really the key issue. But the viability is important. It's one of the reasons we are accepting of the idea of native advertising and sponsored content and so on. We think that there has to be a way for newspapers and online services to be viable, commercially viable. There's no benefit in having them be really pure and non-existent. Doesn't help anyone.
Hi, I'm Miriam Robin from Crikey. A lot of the biggest websites and the most popular websites in Australia at the moment aren't members of the Press Council. I'm thinking of things like The Guardian and the Daily Mail, primarily online entrants here that now are quite significant in terms of traffic. Do you think that's a problem, that they're not joining the Press Council?
Well, they are, actually. I mean, there's been a bit of a transition period, as with all of the media and government policy and privacy laws and so on, in which we're learning how to deal, how to cope with, how to cover, how to be effective in the new environment. So we've steadily been signing up convincing members of the new media or online-only publishers to join the Press Council. So Crikey is a member of the Press Council, Mumbrella is a member of the Press Council, the New Daily, the New Matilda, Huffington Post, which launches today, is already indicated its intention to join the Press Council. BuzzFeed, if I haven't mentioned that already. We've had discussions with Mamma Mia. I think 16 or 17 of the top 20 online-only sites are already members of the Press Council. So it is changing. We're recognizing that need. And our membership drive is, as I said, in two directions. One is to make sure that we cover the online news and current affairs sites. And the other is to try to bring in much more of multicultural press to recognize the diversity of Australian media. The other area we're looking at is major producers of content that are neither exactly online producers or newspapers. So we have a meeting tomorrow morning, for example, with AFL Media. They have a newsroom that's much, much, much larger than most of our member newsrooms. There are hundreds of journalists now. And so should they be bound? I think they should be bound by the standards of the council. They can distribute their content probably much more confidently, and it can be received much more confidently by the platforms if they've agreed to abide by the Press Council standards. There are a number of banks and others. I mean, it's a fine line between journalism and PR in some of those areas, but I think we make fine distinctions all the time. I think we can try to make that distinction where we have groups that are engaged in significant content production and see if they can be involved as members or maybe associate members. The Guardian hasn't been expressed a willingness to join yet, but they're also not a member of IPSO in the UK. So they've got a system in which they're confident that they handle complaints well internally. I can't find a how to complain click link on their website, and if anybody else can, you're more of a gun internet researcher than I am. So I think there are some issues there, but we would like to bring them in. We do recognize that the New York Times has its own internal ombudsman. The West Australian has developed quite a good system of adjudication, which it's got a former Labor, a former Liberal Attorney General, and then another distinguished person. So there are other ways of doing it, and as long as we are all operating in the same mode, we have the same high standards, the same independence and integrity, then I'd be happy sort of to embrace those as associate members of the Press Council, for example.